Realidade virtual para aumentar a eficiência? Essa tecnologia está na Petrobras.
Olá, bem-vindo ao Diálogos. Hoje estamos aqui novamente com Ken Dhaliwal, que é um dos maiores advogados de direito do entretenimento do Canadá. Na semana passada, ele apresentou um panorama de acordos de coprodução e hoje ele vai seguir com mais detalhes. Welcome back, Ken.
Okay, let's jump into part 2. So part 2, we're going to dig down a little bit and we're going to talk about the co-production agreement, which is, sort of the fundamental agreement between the co-producers that sort of governs the relationship. So let's talk about the co-production agreement. Okay, so whenever two or more co-producers come together, you have to have some agreement that sort of sets out what the rules are, what the responsibilities are, and how things are going to work on the production. This is the co-production agreement. Now, under treaty co-productions, you actually need to submit this to the co-production authorities. So it's kind of a mandated document. It has to be set out. There's a certain form to it. And basically it has to be something that the parties sign up because it will determine how things work, things of the responsibilities, how distribution works, how ownership works, and how the financing works. All of the really key things in terms of how the parties are going to come together and work. So it's the cornerstone of the relationship. It's really the governing document of the relationship. And it goes from development all the way through to distribution and exploitation. So clearly we want to spend some time thinking about it. It's important also to take a step back and think about what you're doing in a co-production, right? You're essentially entering into this relationship with another party or parties if it's more than two co-producers. And this is kind of like a partnership agreement. You guys are bound, you producers are bound for the purposes of this production. And it's complicated because not only is it, generally sort of complicated, but you're dealing with intellectual property, you're dealing with rights, you're dealing with money, you're dealing with all sorts of things. And they come together in this ball of stuff. And it's very hard to untangle this agreement. I used to, refer to it like a marriage, but it's actually it's much more complicated than a marriage because of all the sort of things that are intertwined. So be aware and spend some time and understand how this relationship is going to work. Again, this goes right back to the beginning and understanding how important your relationship is with your co-producer. Sometimes people can't get past the co-production agreement stage and they can't actually, figure out how to do it because it takes so long. So basically being aware of that and being aware that you're entering into this, and also be aware of the fact that it's very hard, especially once you've entered production, to terminate a co-production agreement because of the way that productions work and because of the obligations that the co-producers would have entered into. So all of this to say, the agreement, super important. There's a lot of thought that goes into it. There's a lot of thinking about how how people come together. There should also be thought about how people are going to unwind this agreement. And I'll talk a little bit about that a little bit later. Okay, so the point of the co-production agreement is obviously, you need it. It's really, the requirement of a lot of the co-production authorities. But, the co-production agreement, as it says on this slide, and this sounds weird after I just told you how important it is, it's only as important or it's only as valid and has as much value if the parties are willing to abide by the terms of this agreement and not. And what I mean by that is having any agreement, and this co-production agreement is the same, it's only as good as the people behind it. So if someone signs an agreement and they have no intention of abiding by that agreement, the agreement's worthless. So the question then is, if someone breaches the agreement, let's say the co-producer that you're working with breaches the agreement, are you going to take legal action and enforce your rights? If you're not going to, because it doesn't make sense from a cost perspective, then this whole having an agreement, I hate to say this as a lawyer, but having an agreement, it's kind of not quite worthless, but it's kind of like, what's the value in it? The real value and it's, again, this goes back to the start, is your co-producer, knowing your co-producer, being on the same page with them, being on the same place in terms of understanding, and trusting them trusting you, knowing that they're going to, sort of follow through with their obligations, and that you're going to follow through. So it is really, really important to understand that. And I want to say that as much as the co-production agreement is important, the reality is I've seen so many situations where one co-producer doesn't do what they're supposed to do, and the other side, and the party that hasn't done anything wrong, they're the ones that are stuck. They're the ones where they're like, I did everything I was supposed to do. And I'll give you an example. This is, again, goes to the quality of your co-producers. In this, I worked on a Canada-UK co-production many years ago for a bank. The bank basically financed the Canadian tax credits. And what happened was that the way the Canadian tax credits work is that you have to do a filing at the end of production with all of the financial numbers and everything, and then you get your tax credit. So this could be 7 to 10 to 12 months after you close your bank deal. What happened was the Canadian company basically didn't do any filings and was dissolved. And they basically, the Canadian co-producer said, I'm not going to do anything. And even though they owed money to the bank, they just said, I'm willing to walk away. So that left the bank and the UK co-producer in this situation where we're like, yes, we have agreements. So the UK co-producer had agreements where they could have, sued the Canadian co-producer, but the Canadian co-producer had no money. There's nothing there. So what was the point? The same thing with the bank. The bank could sue the Canadian co-producer for not doing what they were supposed to, but there was no money, and they were like flaunting it. So we had to come up with a different situation and a different sort of alternative, which we did. We were able to fix it. But the reality is that if there's a breach by one of the parties, legal action is very expensive and often beyond the reach of producers. So please, when you're doing your co-production agreement, don't have in the back of your head, oh, I'll just sue the person, because the reality is that doesn't happen. It's really important to really be practical about these things. And that is something that, I want to be sort of upfront about. The other, complicating factor is we're dealing with intellectual property. And even if you're in a co-production and you're in the middle of production and this other co-producer isn't doing what they're supposed to, what are you going to do? It's very, very difficult to untangle things. And often when I've seen situations like this, it's basically, you look to the co-production agreement as a guide, and you basically get through the production, and then you deal with it at the end, and figure out sort of how to disentangle. So the co-production agreement is important. In summary, it's very important, and it sets out sort of the obligations. But what I'm really saying to people, don't look at the agreement as the cure for everything. It's a roadmap for how things should work. You have to look at the people behind the agreement and see what they're all about. So again, it goes back to the people and the importance of understanding who they are. So, okay, let's jump to the next point. So I just wanted to, while we're talking about the co-production agreement, as I said, it's sort of the fundamental agreement between the parties. We should talk a little bit about some clauses that are in co-production and co-venture agreements that are often underestimated, or not necessarily, people don't think them through enough. And so sometimes they, you see them in all the agreements, so they they start looking like what we call boilerplate, where they're just there. And it's only when you actually have to rely on them that you start thinking, oh, this is kind of important, I should think about this. So let's cover a couple of the clauses which are actually important and should be carefully considered going forward. So one of the, I think probably the most important, even though I spent some time talking about how it's very hard to untangle from a co-production, things like conditions precedent, termination, and unwind clauses. So lawyers are very strange people, right? We're very odd because we're trained to always think about the worst case scenario. So while you're excited because you're meeting your future co-producer and you're looking into doing a co-production with them and they're excited about everything and the world looks good and blah, 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 your lawyer, upon hearing this, is thinking immediately about all the things that can go wrong. That's what we do. So this is really important for like these concepts of conditions precedent, termination, and unwind are important. So conditions precedent are things that have to happen before you're obligated to, before the contract is in effect, put it that way. Condition precedent, for example, of obligations could be you have to have full financing of the production before the parties have obligations to each other. That's a big condition precedent. Otherwise, it's all just, we're just doing this, but there's no obligations. Conditions precedent could be, that you sign certain performers, or that you have sort of people attached or directors attached, but those are things that have to happen before the contract is sort of in effect. Termination and unwind clauses are what happens if conditions precedent aren't met or things go wrong. So termination basically is what it sounds like. You terminate and the contract is done. Unwind clauses are a bit more complicated in the sense that, how do we pull the rights back out of different parties, that kind of thing. So as I noted earlier, there are some practical considerations in a co-production which make termination and unwind more difficult, and especially than a regular sort of production, especially if production has started. The first is intellectual property and untangling intellectual property rights. The idea is, you need to be able to unwind the rights as much as you can if the co-production doesn't happen. And so you need some clear language setting out on how that's going to work. And it's difficult if the co-producers actually can't agree on how that's going to work. You also need to be clear about, the other things that make it difficult to unwind is our regulatory and third-party obligations. So, the filings you've done with the co-production authorities are the biggest thing. Or if you have a bank involved, how are you doing that? So let me give you an example. So the approval process for treaty co-productions in Canada is that Telefilm, which is our governing authority, provides a provisional approval, which includes both of the co-producers on the provisional approval, saying, you're co-producing with X. If you have a problem with that co-producer, once production has happened, even having an unwind or a termination is going to be very difficult. But it's important to have at least the concept of a termination or an unwind clause in the agreement. So on the following slide is an example of a conditions precedent clause. And this is just to give some background, this is a clause that I've used a whole bunch of times, or some version of it. This particular one is sort of formatted so that it would fit into a Canada-German co-production agreement where the rights are coming from the German group. So this is again, conditions precedent clause, and it's a good clause because it deals with what happens before the co-production agreement is fully effective. So, and in this case, it talks about some conditions precedent having or referred to that have to happen. So in this case, it talks about full financing, and full financing. If full financing is achieved by a date that's in the agreement that currently is an outside date, then the co-production agreement is in effect. If full financing is not achieved by that date, then the clause also goes on to set out what happens with the rights. And this is important because, as I said earlier, conditions precedent and unwind, this is at this point, the production hasn't started, and there may be some rights that have sort of, been created by both the co-producers, but you're not in the state of production, you're in development. And this really says, if we don't have full financing by a certain date, basically we're closing up the agreement and we're walking away. And it talks about the agreement being null and void. All the rights into the production are going to be continued to be owned by the German group. Very important, because if the German group goes off later on and wants to do this project again, they have to have a clear chain of title showing what happened with the rights if this co-production agreement didn't go forward. So when is this, when the question is, when is this type of clause most useful? So it's really most useful to be in a co-production agreement or a deal memo when the producers have agreed to work together to shop the project, to find financing, and it gives them time to provide, and it gives them a milestone, an outside date by which certain things must be achieved. In this case, full financing. And also it says what happens if those things aren't achieved. All things that are very clear and very important when you're dealing with intellectual property rights. And that's why conditions precedent clauses and termination clauses are so important in co-production agreements. Morals clauses into agreements. And so it's something to consider thinking about whether you want to add that the key people on the other co-producer side would be sort of bound by that kind of similar sort of morals restriction to make sure that the other side or that the other co-producer doesn't, for example, the language I've given you, that they don't do something during their private life where they're charged with an offense, that could have some sort of negative impact. So something to think about. It's relatively new. We're starting to see it a bit more, again, more in TV. Next is currency indemnification clauses. Now, again, very, very important, especially in treaty co-productions, because what you've got is, you've got often more than one country, so more than one type of currency. And the idea is that it puts in the co-production agreement some coverage over how in currency are dealt with. And so the concern here is how to deal with changes in exchange rates when money is received in one currency and spent in another. So again, looking at my example of Canada, France, if I'm receiving money in Canadian dollars from the Canadian distributor and I'm spending it in euros in France, how do I deal with that? And how do I make sure that is dealt with? So the language, the clause that I've given you is basically very similar, very simple, very standard clause where it says that the groups, both the co-producers, will figure out collectively how to deal with currency exchange. And what this does is it kind of forces people to think about it, and it doesn't make it the responsibility of just one group, but it makes both of the co-producers think about it. And there are ways to deal with this sort of currency indemnification or currency exchanges. The most typical way is banks will hedge. They do these things called hedging transactions, and and private companies do them as well if they see if you're receiving money in one currency, paying in another, and you've got time differences. It's a way to sort of make sure that even if there's a change in the currency, you're not going to, be at a loss. Worst case situation would be is if, let's say, the Canadian dollar goes way, way down against the euro, all of a sudden, if I'm receiving Canadian dollars, but I'm paying in euros, I have less money to pay. I have less euros. That's not what you want to do. So this is a good clause to have in any co-production agreement that makes the parties sort of work together. Okay, dispute resolution is something, so inevitably we're going to get into dispute resolution with people. And that is something that is, it's not inevitable that you're going to have a dispute, but it's inevitable that, people will think about it, if things start to go sideways, they think about, okay, how am I going to deal with this? How am I going to deal with disputes, and how am I going to take them forward? So there are a couple of different options. In Canada, the sort of the different ways of doing it are there's court, and then there's mediation and arbitration. So on the slide, I've got mediation is non-binding. And so you're not going to court, but you're going to a mediator. And what I mean by non-binding, it's that people basically, the two parties, the two co-producers sit together and they try to figure it out. They try to come to a resolution around any dispute. And if they don't like the way the resolution comes out in a mediation, they're allowed to walk away and maybe they go to court, but it's non-binding, but it's a way of forcing people to come together. Arbitration is kind of the next level of that, but it's binding. And what it usually is under a certain set of rules, they go to an arbitrator, and the two co-producers would try to figure out a way, and ultimately the arbitrator decides how things are done. Those are both non-court alternatives in terms of dispute resolution. The other way, which is the traditional way, is to go to court. Sometimes going to court for a breach, people, that's what they do. Now, one of the downsides, so the sort of the challenges or the different approaches is courts cost a lot of money. They just cost a lot of money. They're not quick, whereas arbitration and mediation can be quite quick. And so courts aren't particularly great when you're in a dispute in the middle of production. And I don't think I've ever seen anything, a co-production, go to court while you're in the middle of a production. I have seen mediation where people are trying to resolve things in the process or in the moment. But again, it sort of depends on the dispute and the situation. Some disputes are better suited to courts, and some are better suited to actually industry experience. So if you've got, for example, an arbitration under IFTA as part of your clause, then that is something where IFTA has an actual arbitrator or set of arbitrators experienced in the area, so they may be better suited to understand what is pay or play, or what is net profits, and how does it work, and that kind of thing. They're industry specific. And the last and not the least important thing is that non-court procedures are confidential. You'll see sometimes, especially in Hollywood, where you see big cases and they're not handled in court. They're handled by an arbitrator, or they're settled out of court, either by binding arbitration or non-binding arbitration. Because this way, if it goes to court, for example, it has to be publicly reported. It cannot be sort of private. And very often, the bigger parties don't want this stuff out in the public. So you have to kind of pick and choose. My preference is to actually use sort of binding arbitration as a clause in the co-production agreement. So on the next slide, I have a simple example of arbitration, and basically, this is language basically that says that if they have a problem, the co-producers will go under the IFTA rules. They'll find a single arbitrator, and they will come up with an arbitration. It's going to be held in English in Toronto. Now, it can be held anywhere in the world. It doesn't have to be Toronto, and it can be held in whatever language the arbitrators or the producers decide. But this is a very, very simple binding arbitration language. It's frankly, it's simple to do. It's faster than going to court, and it's cheaper. That's sort of the big, and it's also specific to our industry, which is another reason where people may want to consider something like this. Okay, the next slide, governing law and venue. Okay, so this is, what law will govern the contract, and where will disputes be heard? Again, this is, people sometimes gloss over it, but it is important, to understand where you want to have any, disputes heard. So the previous slide talked about arbitration and happening in the jurisdiction, or in Ontario, in Toronto. It could be anywhere that you could have your potential disputes decided anywhere. And if you're talking about co-producers in different parts of the world, it is important to figure out where you might want to do that. And it's also important in terms of picking the law of the country. Typically you have two choices. I mean, you can choose, if it's a Canadian co-producer and a Brazilian co-producer, you can choose the law of either country. The producers might want to think about, if you're choosing the law of one country over the other, has the law developed in a way that there would be some sort of certainty about what people are doing in the film and television space. So it's something to consider. Very often the practical reality is that the governing law and the place where disputes will be heard are going to be decided by the majority partner. So the partner in the co-production that has the majority of power, or is the majority co-producer bringing in the financing, they'll typically decide in their favor. I would say that's about 95% of the cases that I work on. The one of the two co-producers is kind of the majority, and they get to decide. In a few cases, we've had, like say it's European and Canada, we've had people say, fine, we'll do the arbitration in London because it's kind of halfway, and they'll choose the law of one of the countries, or they'll choose the law of the UK, and you can do that as well. It's up to the co-producers. But again, something that it's usually just a clause. People don't spend any time on it, but we should think about it, especially in the context of a co-production. just jumping to the next slide. So assignment clauses. Assignment clauses are, the concept is when and how can this agreement be assigned? And that's, again, sometimes it's just in there and it's not particularly clear. Under Canadian law, what you want to do, you want to make sure that the agreement is clear on whether assignment can happen or not happen. If it's not clear, then you might get a default that it can be assigned and you don't want it assigned. So simple example is in the slide there. Again, it's important because it should be in every co-production unit, because the parties need to be able to, in some cases, assign their rights in the agreement to another related party. Often in Canada, what will happen is a parent company will enter into the co-production agreement, and it will, at some point when the production becomes more sort of greenlit, it will assign the co-production agreement down to the single purpose company that is going to produce the show. And you want to be able to do that clearly and without any requirement to go to the other group. So this example in the slide here is basically allows either of the two groups without the prior authority's approval to assign their obligations and rights to a single purpose company that's wholly owned by them. So this is really capturing specifically what happens many, many times is the Canadian company that I'm acting for won't set up a single purpose company for cost reasons or otherwise until we know that we're going into production. And at that point, we set up the company and we push the rights that are in the co-production agreement down into the actual single purpose company. And it's important to know, like, it is one of those things that is, again, sometimes it's just there. You should think about it if it's important or not to you and how you want to do it. And that is the end of my presentation.
Thank you so much for doing this. It was amazing, amazing, amazing.